Thank you. All right, everybody. Welcome. I'm Diane Drain, Co-Executive Director with Crystal Ahart for ACBC and Co-CLE Chair with Lisa Thompson. So today we are going to have Lisa go through this 2.0 CYA from CTA. And she is not going to take, well, I'll let Lisa tell you what she's going to do as far as questions and all here. The materials have been uploaded now to the website. I apologize. They're a little on the tardy side, but no worries, they're there. I also will be posting them periodically throughout this program. So Lisa, take over.
Thank you, Diane. The materials are tardy because they are fresh off the presses because I just finished them about 15 minutes ago. So you guys are hearing the most up-to-date seminar on the CTA as of now. And it could change tomorrow, who knows, because it is new law. So that's my disclaimer. Let me go to my next slide. And of course, my computer's misbehaving. All right, so I'm Lisa Thompson. I am licensed in Arizona, California, and Nevada, and I have been practicing business law for 28 years. I focus a lot on consumer bankruptcy because of my business law practice. So I do a lot of consumer bankruptcy for business owners who have failed businesses and a lot of working with the SBA and EIDLs and tax issues, and I very much enjoy that. But my true love is business law. And if you have questions after this presentation, you're welcome to reach out to me at my CTA website. But also, I am trying to keep my frequently asked questions on my website up to date. With anything that goes on with the CTA. So you're welcome to look for them there. They're in the resources section of my webpage in the CTA section. So I do keep those updated. All right, our goals for the day is to discuss what happened on July 8th and July 24th. And how that changes CTA compliance. There's been other updates throughout the year since this went into effect, and they were really minor. They were more clarifications that didn't change anything. Like, for example, my attorney colleagues, were trying to be really creative and not have to report for your clients. So one of the updates that came out in like February or March was, no, really, US territories count, and you cannot form an entity in Guam and not have to comply with the CTA. So there were things where people didn't really it didn't change what we thought. But in July, Vincent said something completely different than what I had been saying. And I will tell you this, that if you're reading a Fenson update early in the morning and you haven't had your quota of coffee so that you're really functioning, you do not need coffee after that, especially when it says something that you have said the exact opposite of for about 7 months. And so I had to go back and correct some things that I had said, and I'm going to tell you about that in a minute. But I will say that everybody said the same thing, so I wasn't the only one that was wrong. And I know some of the folks that are on this presentation today do not have any working knowledge of the CTA, so I am going to get us all up to speed briefly, and then we're going to talk about the changes that have occurred. And I think it's good to hear the presentation now because I've been working in the area, and so it's no longer talking about it in theory. It's no longer a vacuum. It's no longer, this is how it might work, but we don't really know. And so it's a little more practical. All right, so moving on. So again, I'm putting up my key definitions for people. If they watch this later, they can print this out it gives all the terminology that one needs. For those of you who don't know, FinCEN is the Financial Crimes Enforcement Network. It's a bureau of the U.S. Department of Treasury, just like the IRS is. I've given you their website. There are great materials on the website. And I'm on it pretty much every day for most of the day. But if you have questions, that's where you should go. They've got a lot of guides. They have a lot of guides in multiple languages. So that if know folks that need something in Spanish, there are guides in Spanish. Although I will tell you that the most up-to-date information is in the frequently asked questions. The guides haven't been updated since September or December. So if you really need up-to-date information, you need to go look at the frequently asked questions on FinCEN's website. All right, so this is a housekeeping list and the terms I'm going to use today. You means you, your clients, friends, or family. It's just easier for me to say you. I'm not calling you out, except some of you, because I know you. I will mostly be referencing LLCs because it's just easier and it's the most common business entity. But keep in mind, this is not a law that only applies to LLCs. This applies to every single business entity type that exists in this country. This also applies to both foreign and domestic business entities. Where possible, I will mention that, but I want to make sure that if you work with any clients or you have any friends that are in Mexico or any other foreign country and they're doing business in the United States, that this applies to them as well. Please put your questions in the chat. I'm not going to be monitoring while I'm speaking. Diane will interrupt me if I start speaking another language or I'm being completely unclear and I need to change something in real time. Otherwise, I promise I will answer any question that anybody has at the end of the presentation. And since I've never given this particular presentation, I'll either stay late or we might have a lot of time for questions at the end. So we'll see how that goes. So definitely put them in the chat or write them down, and I am happy to stay as long as you need me to. All right, so the goal of the CTA was to create a database for law enforcement personnel to track human ownership of companies that are generally unregulated. They needed to create a database in real time to thwart money laundering and funding of terrorist activities. And I really wanted to have a cool movie clip or like a TV show to show you the clip to kind of give you the concept. I've been on a hunt, so if anybody finds something, please let me know. But the best I could do was episode 1 of season 1 of Jack Ryan. So the idea is you've got bad guys moving money through companies where the ownership is unknown. And it is very time consuming for law enforcement to have to go to each individual agency to determine the information that they need using subpoena powers. So this is really putting everything in one database so that law enforcement officials can access it when they are investigating money laundering, terrorist activities, and the like. And so they can get that information very quickly and use that to hopefully thwart something. A lot of people say it won't work. A lot of people say it might work. We might not ever know, and hopefully we never have any other terrorist attack on this country. So but that is what they're trying to do, is to create this database to help law enforcement. Now, keep in mind, this database is only for law enforcement. It is only for law enforcement that have a very specific, discrete reason why they need to access it. And it must be in the nature of a money laundering investigation or for national security. They generally have to have a court order. And so it is heavily, heavily, heavily regulated. All of this information that's being provided is not available to the public. So if you, for whatever reason, have an entity where your ownership is confidential, that remains the same. I can't go and see it. If you have a Delaware LLC, your ownership will remain completely 1000% confidential because the public cannot see this. It's only for law enforcement and it's only for very specific reasons. All right, so here's our brief history. Congress began drafting this legislation in 2018 because the US was getting a lot of heat worldwide for their lack of transparency in corporate ownership. And the US was being accused, particularly in the financial industry, of allowing and being a haven for folks to form business entities, form the LLC, get the EIN, put money in it, form another one, shut this one down, pass the money, and on, so that they could come out at the end with clean money. And so it started in 2018 in response to that. Also keep in mind that the European Union, United Kingdom, Africa, most countries have something similar and have for quite some time. When I deal with foreign clients or when I'm talking to other attorneys that don't work in the United States, they're kind of like, okay, well, so what's the big deal? Because we already have that. And if you've tried to get a bank account recently, banks are doing a lot of what's called CDD, customer due diligence. So it's really kind of coming down, and this part of it is creating the database, but you're going to be providing this information all day long. January 1st, 2021 was when it passed. It passed by a 2/3 vote of Congress. So it's a bipartisan act. I don't think that the election will really have anything to do with it. On January 1, 2024, it went into effect. And in 2024, it went into effect. In 2021, I don't think anybody paid attention to it because, one, we are humans, and I'm not thinking about anything that's happening in 2026 right now. I'm having a hard time dealing with, what I'm going to have for lunch today. So nobody paid attention for that reason. And also it's not very sexy. But then on January 6th, we had the Capitol riots. And so nobody paid attention to it at all. But it did go into effect kind of like a dark horse, January 1st, 2024. I have provided the actual code as well as the FinCEN regulations. That's it. There's only two. If you need to see anything about it, that's where you go. They're in the materials. And essentially, new companies must file a beneficial ownership information report, which we're going to talk about extensively, within 90 days of approval of their formation, and they must report their company applicants. Again, we'll discuss that. And the deadline for existing companies that existed on January 1, 2024 is December 31st, and that cometh very rapidly. All right, so other happenings that have gone on. I am hearing a lot of, oh, well, I don't have to do anything with the CTA because it was declared unconstitutional. The CTA is alive and kicking. If I was more computer savvy, I would put up the Simple Minds alive and kicking, and that would be our theme today. You need to be reporting. FinCEN is saying that there is no stay in effect. There was no stay in effect by the Alabama District Court judge. There is a stay as to the plaintiffs in that case. And essentially, the National Small Business United is an organization out of Washington, D.C. that brought this action claiming that the CTA was unconstitutional in Alabama. And the judge, in fact, said it was unconstitutional. It's been appealed to the 11th Circuit. The oral arguments are scheduled to occur sometime during the week of September 23rd. But it's doubtful that that's going to change anything by the December 31st, 2024 deadline. There's also been some other cases that have come out. I believe there's one in Maine, and some smatterings across the country, but there's been no ruling at the trial court level. Also, the states are starting to pass their own Transparency Act laws. So if you're forming an LLC in New York, that came out right before the CTA went effective. California and Maryland also have similar legislation pending. So I don't think that we're ever going to be without this type of reporting. It's just going to be whether it's going to be at the federal level or the state level or both. On January 25th, 2024, the civil fines for violating the CTA were increased to $591 a day. The code and the regulation still says 500. It is in fact $591 a day. It was adjusted for inflation per the Federal Civil Penalties Adjustment Act of 1994. And I have included that in your materials, and I must look at it at least 3 times a week because I'm, to my knowledge, the only one talking about it. Everybody else is like, no, it's $500 a day. And then we also have the CPA that my friend talked to and asked about the, what she needed to do for the CTA, and the CPA said, well, it's not happening. So there's a lot of misinformation out there. I will tell you, look at the Federal Register. In fact, this civil fine has gone up. Also, FinCEN has provided additional guidance. If you are working in this area or you are filing any reports for anybody at all, you need to subscribe to the FinCEN email service where they send those updates to you so you get them in real time. It's definitely a disservice to your clients if you do not. The other thing that's going on is that 33 million companies were estimated to be affected by the CTA, and about 3 million have filed their BOIRs to date. So if you do the math on that, my humble opinion, for what it's worth, is the FinCEN platform, which used to be called the BOSS, but I understand that it has been changed to the BOIT. I don't know how people are saying that, but is going to crash. So I would file your reports now, because starting in October, it would have to be something like $350,000, 350,000 reports would need to be filed on this platform a day for everybody to meet the deadline. So as a practical matter, what does the CTA mean? It means that any business entity formed or registered in the US is considered a reporting company, and it must report its human beneficial owners. And this is my attempt at showing, how it peels back the onion. The CTA applies to foreign businesses that are registered or should be registered to do business in a state. So for example, you can have a foreign company that's doing business in a state. You can also have, other, you can have a California company that does some business in Arizona, and it may or may not have to formally register as a foreign company doing business in Arizona. It needs to follow the Arizona statute on when that needs to happen. Most often it doesn't ever happen because there's no penalty for failure to register. The only thing that happens to a foreign business doing business in Arizona, if it has not registered, is if it gets sued, it may not maintain a defense, and it may not bring litigation. But how does it remedy that problem? All it needs to do is go and register. So that's why I put in the or should be registered within the state. If you've got a foreign company, you've got a Mexican company that's working in a state that doesn't require registration of foreign companies, then it is not going to have to report under the CTA. So the CTA is not one size fits all. So just like how we deal with federal bankruptcy law, think of it that way, right? Bankruptcy law is the same across the nation, but we all know that it's different in Arizona because we have different exemptions than someone in Nebraska or someone in Florida. The Corporate Transparency Act is the same way. Someone who has to file a beneficial ownership information report in Arizona may not have to in Florida. One of the biggest examples is in Delaware, if you're a general partnership or you're a statutory trust, you are considered an entity in Delaware. You are not in Arizona. So general partnerships and trusts in Delaware are having to report under the Corporate Transparency Act, and those same entities in Arizona are not. So think of it that way, and it's very, very state specific. And you just need to be cognizant of that. So, is your business a reporting company? And like 99.9%, yes, you're a reporting company. I find it so funny. This is designed for all companies. I mean, the question really is, are you exempt? Right? That's where the analysis comes in. But to be clear, all LLCs, all corporations, all LPs, all LLPs, all LLLPs are reporting companies. This includes us. Professional corporations are also included in that. Professional limited liability companies are included in that. You do not need to file a BOIR if your company is exempt, but every single company is a reporting company. All companies working or doing business in the United States are probably a reporting company, unless you are a sole proprietor or a general partnership, and you're in a state that doesn't require you to do something to form that. So, and it doesn't matter if you formed something in Guam, same thing, but you got to look at the laws that govern businesses in Guam. So, and it really is, did you have to do something to form your entity? Not you and your friend saying like, hey, let's sell cookies. That would be a fun thing to do. That's just forming a general partnership. You didn't have to go to the Secretary of State to file paperwork, and you didn't have to go to the Corporation Commission to do anything. But if you did, in order to form your business, then you must go ahead and file your beneficial ownership information report unless you are exempt. Here are the 23 exemption types. I'm not going through them. I've highlighted the ones that are most relevant, but you'll see here that really the exemptions are for businesses that are typically regulated by the government. And why is that? Well, the government already knows who owns them because they're doing a significant amount of reporting. One of the ones that is used probably by a lot of law firms is the large entity exemption. And the short version of that is if a company has 20 employees or more and full-time, not hybrid, not contractors, they have 20 full-time employees or more, and they have filed tax returns that have $5 million in gross income and receipts, and they have a physical location in the United States, they are exempt from reporting. Charitable organizations such as anybody that has a 501c status. There's like 3 others, and you can look at them. They're pretty narrow. But if an entity has a 501c3 status or 501c status, they are considered exempt from the CTA. However, keep this in mind if you form nonprofits. When you form a nonprofit, you do not have a tax exempt status from the IRS for at least 9 months right now. So those entities are going to have to report, because it's not, hey, we're going to get it. It's, do you have it? And then we're going to talk about inactive entities or the inactive entity exemption extensively in a minute. All right. So the beneficial ownership information report contains, the name and the trade names of the company, the address of the company in it. You cannot use any PO box. And you have to report an EIN or a TIN. And that's one of the things that changed. I just kept it on the slide because this is what the code says. For beneficial owners, your legal name. If you like the name Bob and you don't particularly like Robert, that's cool. I will call you Bob, but on your BOIR, you need to use your full legal name, preferably the one that is on your driver's license or passport that you are going to submit to FinCEN. You also have to use your residential address and you have to provide your date of birth. So again, this is information that the government already has, various agencies, we're just putting it in one place. All right, so beneficial owners are the humans that have 25% actual ownership of the company and or exercise substantial control in the company. We are not digging deeply into this at all today because it's not really the purpose of our presentation. But exercising substantial control in the company means, are you on the board of directors of the corporation? Do you have the ability to have a vote in hiring or firing officers in that corporation? Are you the manager of an LLC? Managers are going to be required to report. Your officers of corporations, your directors of corporations, depending on what the bylaws say. Also, if you have general counsel, depending on what his or her role is, they could possibly have to report. So there's some analysis that needs to happen. If you've got stock options, that's an issue. If you have, if the business is owned by another business, you've got to keep going down and doing the math to determine if the ultimate human owner has 25% actual ownership. So anytime you have a business owned by a business, you're talking big time analysis, and you really got to think that through. All right, community property states, again, state by state. One of the things that I think is not happening is none of the third-party filing companies that I have seen, and I have done their questionnaires, are asking anything about, are beneficial owners married? And in Arizona, we're a community property state. There's 9 community property states. And, think about what we say to people who want to file a single spouse bankruptcy. What do we say? They say, that's her debt. That's not my debt. We always say it's community property state. They could come after both of you. What's, his is yours, all of the various sayings that we have. I think if a spouse has disclaimed an ownership interest in the business, then there's no reason that a spouse would need to report. If a manager of an LLC is married, well, that doesn't matter because being a manager isn't being an owner. But I think that there needs to be some analysis as to whether or not a spouse needs to report on the BOIR if you're in a community property state. And there is no requirement or there's no penalty for over-reporting. That is not a problem. So I'll tell you, in my personal circumstance, I'm a professional corporation. I'm a lawyer. I cannot have anybody else own my professional corporation unless they are a licensed professional. My husband is not a licensed professional. My professional corporation is owned by my living trust, which is just my personal living trust. I got married long after I had formed my business. I think there is an excellent argument that I do not need to report my husband as a beneficial owner of Thompson Law Group PC. But I went ahead and did it. And the reason why I did it is it doesn't hurt him. And he's reporting anyway on his companies. But also, I don't want to be the one making law. I don't want to be getting a love note from FinCEN saying like, hey, why didn't you do this? So I just went ahead and listed my husband. I think that, if my clients had the same situation and I told them, hey, I think there's a good argument that you don't, I probably would make sure that they signed something, perhaps in blood, that I told them that in case FinCEN came a calling. But keep in mind, it is very clear that this is state by state. And, we're a community property state. So unless there's been some active disclaimer on a business, I believe that spouses need to report. All right, so these are the deadlines. I'm sure most of you already know them. I'm not spending a lot of time here, except, the deadline for existing companies that existed prior to January 1, 2024 is by the end of this year. So you need to have filed by December 31st, 2024. And any new business that's formed during 2024 has 90 days from the date of formation, which is actually a bit of a misnomer. It's like 90 days from the date of formation or 90 days from the date of approval of formation. Just if you're doing this, it's 90 days from the date of formation. Like, don't mess around with when does the ACC actually approve my LLC? You do not want to play those games. I would just go ahead and get it filed. Any reporting company that is formed after January 1, 2025 only has 30 days. Everything in 25 is going to be 30 days or less. So, if there's changes that need to be made, if there's corrections that need to be made, or a new BOIR needs to be filed for a new company, 30 days. All right, if you miss the deadline, 591-day civil fines. Let's be really clear, and you guys can look at the statute. I've read it several times because when this first came out in 2024, everybody was saying, and the Journal of Accountancy even said that the fines are capped at $10,000. That is incorrect. That is not what the statute says. It is very clear that civil fines are civil fines, and there can be possible criminal penalties of an up to $10,000 fine, or imprisonment of 2 years or both. So this is in addition to. I also do not believe that these penalties are going to be dischargeable in bankruptcy under 523A7. I do not think, I mean, they are definitely punitive. They are designed to make people comply. I think that if someone gets hit with these fines, that they could be devastating. I do not believe that on January 1st, 2025, folks are going to get a letter that says, hey, you didn't report. Come on, give us some money. I don't believe that that's going to happen because there's no mechanism to do that. I think it's going to be more if it's going to be like an IRS audit, right? You filed your taxes and that's cool. And you're like, yay, my taxes are done. But in 4 years, you might get the letter saying, hey, you didn't do it correctly. I think that if for whatever reason a business comes across FinCEN's radar, that's when they're going to be looking. And potentially there's going to be some fines. And they had to put in steep fines. They had to, because otherwise nobody's going to do it. And in Arizona, you have no obligation to file an annual report for your LLC, and you have 30 days to report any changes that occur. And what happens to you if you don't report the changes that occur in your LLC? Nothing. So what do my clients do? Nothing. It is very rare for me to read someone's information off of the Arizona Corporation Commission website and have it be accurate. It almost never is. So, there had to be, in my opinion, some kind of penalty if for failure to report and for failure to keep things updated. Oh, and I found a typo in my newly minted presentation. Law enforcement personnel are subject to these same fines if they fail to or follow the CTA, and there's a very strict protocol, as I mentioned earlier, for disclosing information or even being able to access the platform. And I gave you the Federal Register so you can look at it. All right, so what changed on July 8th? So what we had been saying, my colleagues and I that are working in this area, is that, if you dissolved your company by the end of 2024, no worries. You don't exist. You beat the deadline. There's no reason why you need to report to FinCEN. That is incorrect. FinCEN came out with clarification in its frequently asked questions saying, hey, if the company existed and was not permanently, formally, and irrevocably dissolved on January 1, 2024, then it is subject to FinCEN, or is subject to the Corporate Transparency Act and must file a beneficial ownership information report unless they are exempt. And it does not matter if they are dissolved by the end of the year. So again, if you have an entity that existed on January 1, 2024, it is subject to the Corporate Transparency Act. It is a reporting company. If it's exempt, then you don't need to worry about it. But if it is not exempt, then you need to file a beneficial ownership information report for it. Now, FinCEN was abundantly and unequivocally clear that it does not consider corporations and LLCs that are administratively dissolved to be permanently, formally, and irrevocably dissolved. Like they were very, very, very clear. And so in Arizona, you've got 6 years if you're a corporation or an LLC that was administratively dissolved, that the LLC or the corporation can go in and reinstate itself. So, you know, technically, those aren't permanently, formally, and irrevocably dissolved. They're probably going to be exempt because of the inactive entity exemption. But again, it's something to consider. Voluntary dissolutions, if you voluntarily dissolve a corporation, that can be revoked for up to 120 days after its effective date. And with LLCs, they can rescind their dissolution if the articles of termination have not become effective. But once you have that certificate of termination, there is no way to reinstate that LLC. It's done. The interesting thing is the corporate statutes, you have 6 years to reinstate. And that's cool. You can go back to the way you were. It, reverts back. It's like nothing happened. LLCs, you have 6 years after the effective date to reinstate, but 6 months after the effective date of your administrative dissolution, they can give away your name. So I just find that interesting. With corporations, your name will still be there apparently. And I don't know how an LLC would ever get administratively dissolved anyway, because there's no reporting requirements and you get administratively dissolved for failure to do something. I suppose if you didn't have a statutory agent, that might happen. All right, so what changed on July 24th? Companies that are treated as disregarded entities for taxation purposes no longer have to obtain an EIN or a TIN. And for those of you who don't know what those are, that's an employer identification number or a taxpayer identification number that is used by businesses to do any kind of tax reporting with the government. So you no longer have to get an EIN or a TIN solely for the purposes of filing a BOIR. And essentially this is just aligning with what the IRS says, because the IRS does not require businesses to get an EIN or a TIN. I think that it's best business practice to get an EIN or a TIN, because why do people form businesses? They form them to have personal liability protection. And also, in order to maintain that personal liability protection, they need to show that they follow all corporate formalities. And one of those would be, well, I don't use my social security number for my business entity, and I went and got its own EIN or TIN. But if you've got a company that has no EIN or TIN and you're going to shut it down, or it just doesn't want to get one, you may use the owner's social security number or individual taxpayer identification number instead. If it's a foreign company and it has no taxpayer identification number, it may provide a tax identification number that was issued by a foreign jurisdiction and the name of that jurisdiction. So this is kind of a huge change. It's very good for business owners. It's definitely good for foreign reporting companies that they don't have to do that. And the funny thing is, I had met with some clients of a colleague of mine who was filing their bankruptcy, and I was doing their business shutdown. And I had talked to them in June, and they had one business that was an ongoing concern, so we were going to shut that down prior to the bankruptcy. And they had another one that was kind of like the hobby business, right? Like it was formed during the pandemic, and it was this idea that she was going to do something with a hobby that she does, and it never got an EIN. So this is June, and I said, okay, well, we have to we're going to go ahead and terminate the LLC. And so it was no big deal on the hobby LLC because we were just going to shut it down. And I didn't think that it was going to need to report the ongoing concern. We were going to shut it down and file the BOIR. Or I'm sorry, we weren't going to file anything. So we were just going to file terminations. So then July 8th comes, and I had to call them back and say, hey, remember that conversation where I said you were good with the Corporate Transparency Act? Well, now you're not good. So as part of that, I said, you need to go get an EIN, because Fenton was very clear that all entities had to have an EIN or a TIN to file their BOIR. So I had this poor woman go get an EIN, which is not hard, but it's kind of silly, for her business so that we could file the BOIR and then terminate it. So instead of just terminating the businesses, we had to file BOIR for both of them. And I caught them between July 8th and July 24th. So she did in fact have to get an EIN because I just didn't know. Anyway, luckily they were good clients and they weren't grouchy with me. All right, so the good news, bad news is, entities that are irrevocably, formally, and permanently dissolved by December 31st, 2024, but they still have to file a BOIR because they're not exempt. They only have to do it once. There's no updating obligations. They just have to file it. There's not even a place on the, when you're filing the beneficial ownership information report, there's no place for you to say, like, we really don't exist, right? So you just need to file this and then you're done. There's no obligation to keep it updated. All right. So I think that a lot of these entities are going to be exempt because of the inactive entity exemption. So given the new guidance in July 8th, you've got a company that's going to shut down in 2024. You know that it is a reporting company because it went to the Corporation Commission to file its articles of organization and become an LLC. So it's a reporting company. Now you need to determine if it's exempt. So it has to meet all of these criteria. So it had to be in existence prior to January 1, 2020, which is why my client had to go ahead and file a BOIR, because even though she just kind of formed her business on a whim, she did it during the pandemic. So it wasn't in existence prior to 2020, and therefore it had to go ahead and file a BOIR because it wasn't exempt. So the business could not have been engaged, or is not engaged in business. It has no foreign ownership, and it had no change in ownership in the last 12 months. So if you have foreign ownership and you're like, well, I'll just change that. Well, if you've had any change in ownership in the last 12 months, you get kicked out of this exemption. If the company has not received any funds in an amount greater than $1,000 in the last 12 months, and it cannot hold any assets. And I'm sure y'all are going to think that I'm silly for saying this, but you need to ask your clients all of these questions, even if it seems silly. I've had clients where I've asked them, hey, first of all, you're going to say, do you have any other LLCs? And your client's going to say, no. And then you're going to go look on the Corporation Commission website and you're going to run their name and you're going to say, well, wait a minute, what about this LLC? And they're like, oh, I don't use that anymore. It's defunct. I haven't used that for years. It's dead. Except they never did anything to kill it. So it's still out there. And I'm sure my bankruptcy colleagues have had the experience of a trustee going, well, so what's going on with your LLC? And you're thinking, what LLC? My client is a truck driver. Like, what are you talking about? Like, we didn't have it. He said he didn't have any LLCs. Um, so, and if you run searches on your clients with the Corporation Commission, E Corp does not like periods. So, like if I put in Lisa C. Thompson, with a period, I will not show up anywhere. And if I put it in without a period, then I show up. So run every mutation of your client's name, but don't use any punctuation. So you've got to meet all of these criteria in order to have the business be inactive. And I'm still advising my clients to shut down their businesses if they're not using them, just because I don't want them to have to maintain this. So if it truly is an inactive entity, go ahead and shut it down. They don't have to report. If it was an entity that we were going to shut down and terminate prior to December 31st, 2024. We're still going to do that, and we're still going to file the BOIR. All right, those were the big changes. I'm going to talk about a couple things just to make sure that everybody's clear. I have actually had 2 attorneys who form LLCs say to me, I mentioned something about the CTA and asked them if they had a fence and identifier, which I will get to. And they were like, "What are you talking about?" And I said, "Are you forming LLCs?" And they said, "Why, yes, I am." I'm like, "Well, you need to be reporting to Fenson." And they had no idea what I was talking about. So, if you form LLCs or you advise folks on forming a company, say like, "Hey, it's a really good idea for you to form an LLC, or you need to do this kind of business structure and you need to form this type of entity," then you are a company applicant. Now, this only is for after January 1st, 2024. So nobody freak out and think like, "Oh my gosh, I have formed so many entities in my career." This is only for new entities after January 1, 2024. If you have advised someone to form an entity, you are a company applicant. And if you have had your paralegal actually form the entity, then that person is also a company applicant, and they must provide their personal identifying information to the company or to the reporting company so that it can report it to FEDSA. Right, because the reporting company is the one responsible for making sure that the report is filing or filed. There's no way I'm giving that information to my clients. There's also no way I'm allowing my clients to file something with FinCEN that potentially could get me in hot water at $591 a day if it's either done wrong or not done at all. So in my practice, if you would like me to form an LLC, I am also filing your BOIR, and I do them at the same time. So I form the LLC, we get the EIN, and then the BOIR is filed, because I as a company applicant am liable just as well as everybody else is. So you really need to think about that. If you use a service such as like CT Corp, LegalZoom, any of those, or a third-party filing service, the person, the human that actually files the articles of organization or incorporation is the human that is the company applicant and must report to FinCEN, as well as you, the person that was directing it, as well as the beneficial owners. So it's not the law firm. Company applicants can use their business address in lieu of a residential address, but that's the only difference. It is the actual humans that are doing the advising and the reporting. Now, if you want to avoid this and you were possibly going to let your clients, file their own BOIR, you can get what's called a FinCEN identifier. And it's a 14-digit identifying number that FinCEN will issue to you. I have mine right here. I use it all the time. It like a choir of angels came down when I got the FinCEN identifier, because then I didn't have to upload my passport every single time that I was doing something that required me to submit my personal identifying information to FinCEN. So now all I do if I'm a company applicant is I input my 14-digit code, and FinCEN already knows who I am. If I ever decide that I am going to move, or I need to renew my passport, or something changes where I need to update my personal identifying information, I only need to update it once. So even though I'm a member and a part of many different companies such that I have to report to FinCEN, I will only have to do it once because I have used my FinCEN identifier. Now, company applicants do not need to, they basically file one time on the beneficial ownership information report, and that's it. They're out. They do not have to worry about anything that reporting company does again. The reporting company still has update requirements, but the company applicant is no longer a part of it after the initial report is done. If you have a FinCEN identifier, you have to maintain it. There's no ability to cancel it as of now, but I think that will change. If you have clients that have multiple businesses, it might be a good idea for them to get a FinCEN identifier. Otherwise, every single time you go to report, you got to upload the passport, you got to input your date of birth, you got to input your residential address. So sometimes it's a mechanism to make it easier. So you can only file your BOIR online, period. That's it. There's no exception to that. You file it at fincen.gov. You need to have all of your information ready. You cannot stop and start. You can also use a third-party filing service. The filing services are saying like, hey, we got your back. We have a questionnaire. We'll let you know if you need to file or not, or who needs to file for you. Again, I caution that in the sense that you need to make sure that that third-party filing service, if you are relying on them to tell you what needs to be in that beneficial ownership information report, that what needs to be in there, or that they are state specific and they are going to take into consideration basically our job and legal analysis. There's no filing fee and there's no annual reporting requirements for FinCEN. However, I think this is terrifying. Anytime you move, anytime you renew your driver's license or your passport, anytime you have someone leave, buy out, die, etc., you have 30 days to change your beneficial ownership information report. If you have a company that's exempt right now, they had 20 full-time employees and they met the large company exemption, and then all of a sudden they lay off 15 people. They no longer meet that requirement to be exempt. They need to go in and file an initial BOIR because their business owners are going to be responsible personally if they do not. So it's really good that we don't need to annually report, but I think this is going to go off people's radar to the extent that it's even there. And I'll tell you, I already have a tickler in my calendar for when I need to renew my passport. So I remember that I need to go and update information with FinCEN. And I talk about this every day, all day long. I've been talking about CTA recently, and I'm still worried I'm going to miss it because 30 days moves really quickly. And I moved my office last year and I'm still changing the address, and I thought I did really good on that. So I think that this is where people are going to get burned. I think that fines are going to be assessed more here than any place else, because FinCEN's going to know about you. And also with new entities, I think those are going to get caught up as well. All right, so helpful hints. If you're doing this yourself, use your real legal name, like what's on your documents. Use your company's real legal name. I am blown away by the people I talk to, and they have put on my intake, this is my legal name, and I go to find them, and that is not a name that is with the Corporation Commission. And they said that they were formed in Arizona because they don't know what their legal name is. So make sure that that's accurate. I think that you should verify that the information matches on everything and take steps to make sure that it does. Again, if anybody's ever looking at these reports, they're going to be checking you out. So, your records with the Corporation Commission or the Secretary of State need to be accurate. Your tax returns, I am stunned, absolutely stunned when I look at my clients' tax returns for a bankruptcy, how the EIN number is wrong, the businesses are not listed, or they're listed with the incorrect name. Really, some attention to detail needs to be paid on those things, and really make an effort to stress to your clients that they need to check that stuff out. I would choose your passport or your driver's license based on the expiration date. I just renewed my passport last year, so that's what I'm using because my driver's license is going to expire sooner. Subscribe to Fenton updates if you are going to be doing this work at all. I am not suggesting that you have to do this work for your clients. I don't do divorces. I don't do family law in any way, shape, or form. I don't do personal injury, but I know people that do. I'm going to identify it for my clients like, hey, you might have a personal injury suit. You should go call my friend whoever. Or, hey, the cops are calling you. You need to call my friend Al McDonald, right? I'm not going to go do criminal work, but I know who to send them to. I think that because so many people don't know about this law, you're going to look like a rock star if you tell them, like, hey, I know you're a business. You need to talk to someone to make sure that you comply. Um, I don't know that you have an ethical obligation to do that, but it might ultimately be a marketing opportunity for you because they're going to have a warm, happy feeling that you told them about the law and you saved them from getting fined by the evil Fenton. My other suggestion is when in doubt, report. Um, there's no problem with over reporting at all. And so if you don't want to be making new law or getting called out by Fenton or getting just a little love note saying, what's up? I would go ahead and report. Time flies. I do it now. I would get off of this seminar. Don't even listen to me anymore. Go do your beneficial ownership information report or get someone to do it. Do it now. Because before we know it, it's going to be the December holidays and um, and then it's going to be done. So, and I also, my personal opinion is the platform may not make it. And Fenton hasn't been very forgiving about, what happens if something goes wrong. Um, they're kind of like, well, we told you, and so you need to be doing these things. All right. This is going to be a cost of doing business. So it's just something that we need to get used to. And if you need to talk to me, you are welcome to. As I said, I have frequently asked questions on my website. Right now, they're under resources for the Corporate Transparency Act. I keep those updated. If you have friends or family or anybody that needs to have some information on the CTA, have them look there. They're pretty detailed and they're in English. Also, the Fenton website is excellent for providing information as far as what needs to happen, and that's where any BOIR needs to be reported. If you have questions, I'm happy to stay on, and just so I don't get in trouble with the big bosses, um, this is just the disclaimer. So my opinions are mine, and I hope I didn't say anything that was incorrect, but this disclaimer for ACBC, the organization. So are there any questions? And there's 34 things in the chat. Okay. So I'm happy to take down my presentation and just have a conversation with anyone that wants to pop on. All right, that makes it easier for me to read the chat as well. All right. All right, so the information is being stored on a database. It was called the Beneficial Ownership Secure System. It uses the same protocols as that of the IRS. Again, both are under the guise of the Department of Treasury. Law enforcement officials may not access it unless they have a specific reason. It has to deal with specifically national security and or a money laundering investigation. In most instances, they need to have a court order, especially at the state level. If state organizations, I'm sorry, law enforcement agencies need to access it, they need to have a court order. They can't just randomly say, like we see on TV, which isn't accurate, like, hey, can you run that for me? They will get fined $591 a day. Their criminal fines are up to 25,000, and they could go to prison for 5 years. Or if they violate CTA and they're doing something else bad at the same time, it is much higher. I think the fines are criminal fines are $100,000 and 10 years in prison. So they are taking it really seriously. Can the business snail mail or fax the BOIR? The answer to that is no. Sole proprietors and sole practitioners do not have to file a beneficial ownership information report with FinCEN. It hinges, those people that have to file are the ones that needed to do something to form their business. So if you were just like, hey, I'm gonna go out on my own as an attorney. I'm going to go put a shingle outside my door. I'm an attorney, and you didn't go to the Corporation Commission website and fill out articles of organization, and you're just a sole proprietor, then you have no reporting requirements at all. Because you didn't do something to form your entity. And even if you're a sole proprietor and you have an EIN, that's awesome, but you didn't do anything to form your sole proprietorship other than existing. So you don't have any CTA requirements. Let's see. Newly created large company is expected to have well over 5 million in gross sales. However, the year of creation will have less than 5 million in gross sales since it started operations in the company. All right, is this large company exempt? The answer to that would be no, because it hinges on have you filed tax returns that show 5 million. And I think this is going to be one of the conundrums for folks. It's like when I was talking about a new nonprofit. They're not going to have the nonprofit, the tax exempt status, the 501c3 status for a period of time. So they are going to have to file a BOIR, and then they're going to have to amend it when they become tax exempt. So that large company is going to have to file a BOIR and then amend it when it files its tax returns for 5 million in gross sales, because they're not going to allow you to say, well, we think we're going to be like that. They want tax returns to have been filed, and then they need to be monitored every year to make sure that they maintain that. And again, with the employees, and they have to have a physical presence and all of that good stuff. If the parties have a prenup, does that matter? I think it does in the analysis. So if they have a prenup, I think, that gives you more of a reason why you don't have a spouse that has ownership just by virtue of being a spouse in a business. So I think definitely, if there's a prenup, if someone signed off, I have clients who routinely do not have their spouses sign off on their business because they're in business with a friend and they don't want to be in business with someone's spouse if something, God forbid, happened. So yeah, I think if you have a prenup, you have a postnup, and also your clients honor it. And it's not just like, oh, we just did this. So I think that would be an argument against having a spouse have to be included as a beneficial owner. Yes, in fact, so the question is, if someone operates an LLC selling items on eBay from their apartment, they need to update their address every time they move? Yes, in fact, they do. That is correct. if I formed an LLC for a client in 2024 and have already missed the deadline, will my client automatically be fined? I would go ahead and just get that BOIR report filed. I don't think anything is going to happen very quickly. So you definitely want to just get that filed. I actually had someone that formed an LLC for herself, and came to me on another matter, and I was like, hey, you formed this. I don't think that the fines are, I mean, they're designed to be punitive, but they're really designed to make us do this, right? So I think if you go ahead and get something filed with Fenton immediately, you're going to be okay. I would like to know how the government plans to enforce whether a company has reported if the information is only available by court order. Well, I mean, Fenton has access to it. I'm talking about other government agencies that would like to use it in their investigation. So if the FBI wants to look at it, the FBI can't necessarily look at it, but Fenton can. But also there isn't any mechanism right now to like cross-check. Right. So I think what's going to happen is there's going to be an investigation. And even if there's a bad guy company doing stuff, bad guy companies still need services from good guy companies. And so I think that there might be a check on every, company that the target is working with, and just to verify that they're not a part of any kind of nefarious scheme. So I think that is when, fines are going to pop up. I also think at some point there will be checks, but like I don't think there's going to be an active like let's download everything from the ACC and check it. There's nothing in place like that right now. And the penalty for failing to update the BOIR is $591 a day until it is updated. And if you're really bad, then on top of that, you can get up to a $10,000 fine. And which at that point, if you're in that category, the $10,000 fine is nothing. And you could also go to jail for 2 years. So if someone has an inactive LLC that was formed many years, but it was never active and still isn't active, they will still have to file a BOIR even if they dissolve the LLC formally with the ACC by the end of the year, this year. No, they would not, because if they were in existence before 2020 and they didn't do anything and they dissolved by the end of this year, one, even if you kept it in existence, like you're like, I just like this LLC and I want to age it, I'm going to use it at some point in the future, it would be reporting because it's inactive, right? Because it never did anything and it was before 2020. So it could just sit. You also could just dissolve it or terminate it, and that would be fine as well. If you let it sit and you don't file a BOIR for it, which you shouldn't because it's an inactive entity, and then later you go and you use it, at that point you have 30 days to file the initial BOIR report because it will have lost its exempt status. So keep in mind, in 2025, the answer to everything is 30 days. Oh, wait, everyone stop, whatever you're doing. Fenton uses calendar days. Calendar, not business days. So everything that we think like, oh, it's 10 days excluding weekends and holidays, or it's 10 business days. No, it's calendar days because it's all electronic. I am so sorry. I need to make a really big slide for that because that does make an absolute difference. So it is calendar days for everything. So it's 90 calendar days. It's 30 calendar days. Those are your deadlines. Okay. I understand that if the LLC meets the definition of an active entity, it doesn't have to report, but these LLCs I'm referring to were formed after 1/1/2020, which takes them out of the definition. Then yes, in fact, Scott, they would have to report. It's just like the one I was talking about. So they need to file a beneficial ownership information report because they do not meet the 6 criterion of the inactive entity exemption. They can use the social security number or individual taxpayer identification number of the beneficial owner and file that report. They only need to do it once. I would do it now and I would shut them down. And if they don't want to shut down, that's cool. They still are going to have to file a report. If an LLC is owned by a trust, is the LLC required to submit a BOIR? So here's the deal. So trusts are not considered entities in Arizona. They're just a estate planning tool. You don't have to do anything to form the trust. Like you do not, okay. You have to go to an attorney's office or do paperwork to form your trust, but you're not going to the Corporation Commission or the Secretary of State and saying like, hey, I want to have a trust. In Delaware, you do, but in Arizona, you do not. So the trust is not a reporting entity, but the LLC that is owned by the trust is a reporting entity and it is required to file a beneficial ownership information report. Every beneficial ownership information report has to report humans, right? So you need to look at the trust, and if it's just a living revocable trust, like pretty much everybody has, like I have, you look at who's the trustee, who has control over it. And that's the person that really controls the LLC, and that would be the beneficial owner. So if you have a husband and wife or two spouses that have a living trust, then probably you're going to be reporting both spouses as the beneficial owners of the entity. It gets super complicated when you have an LLC that's owned by another LLC that's owned by another LLC, because at the first LLC, you have to it doesn't have any human owners. So you're going to list whoever the manager is, and then you got to look at the second LLC and see who the human owners are. And if it doesn't have any human owners, you list the manager. And then if you go to the third LLC, you keep looking and going down the chain until you get to human beings. They have to be reported on the beneficial ownership information report. If a lawyer gets a FENCEN identifier, can you use this to file a BOIR for your business clients? Yeah, absolutely. Well, okay, you can use your FENCEN identifier for any time you file, but if you're just filing BOIRs for your clients, you're not putting in your personal identifying information. All you're putting in is, I'm Lisa and here's my email address. Because keep in mind, if you're going to do this work, you're certifying that everything that you're giving to FENCEN is true, accurate, under, like you're certifying under penalty of perjury. So do not do it lightly. Make sure that you are covering yourself and make sure that you have a way to verify that what your clients are telling you is true. But you do not need to use a FENCEN identifier if you're just filing the BOIR. If you're a company applicant and you do formations of any type of company, I would absolutely get a FENCEN identifier and use it. How do you treat trustees of the living revocable trust as members for BOIR reporting purposes? You go ahead and you list. So like if I had the Lisa Thompson and Rob Allritz, my husband, living trust, and we owned a business, our trust owned a business, I would take the position that we are the beneficial owners, because that's just a document saying, this is what happened if God forbid Lisa dies, and this is what happens if God forbid Rob dies. We didn't do anything to form that with a regulatory agency. So therefore it's not an entity and it's really just us, which is what we do in bankruptcy anyway. If there's a trust, we prefer not to have a trust, but we usually just say, the trust are the debtors and the property is the debtors. All right. So the living revocable trust, again, you don't have to have an EIN with the new guidance that came out from so first of all, the revocable trust is not going to be reporting, but any entity that was reporting doesn't have to have an EIN anymore. If it doesn't, this is in alignment with the IRS. You can use the beneficial owner's taxpayer identification number or their social security number. And again, trusts aren't going to report because they're not an entity unless you're in Delaware. So ownership of the trust is just the people who are the owners. And I think that trust can get really weird. I have a client that has an irrevocable trust, and the good thing is it's gonna go away. And so we don't really have to deal with it, because I'm not even sure who would report on that. I think it would be the trustee for sure. And there's some other things that you need to think about, because again, this is also substantial control. Who controls the reporting company? So you need to look at that. Can I have my retired attorney call you? Um, the Yes, you can. Um, yes, Wendy, of course you can. Let's see. I moved to a different state last year. I'm still updating my address, and it's one of the hardest activities to move. Yes, I agree with you, Frankie. So when did the penalties begin on updating the BOIR? Do owners have a grace period? Your grace period is 30 days from the time you move. Nobody should be really having to update BOIRs right now, unless they were Johnny on the spot and filed. They're one of the 3 million that have already filed. So it's 30 days from the time anything changes. And again, calendar days. And I wish there was a grace period, but there is not. In fact, Fenton said that if in fact there's someone won't give beneficial ownership information, they're like, "Nuh-uh, I'm not going to give it to you." Like, so let's say you have 5 people and 4 are going to give the information and one's just like, "No." They're like, "Well, don't know what to tell you. You need to file your beneficial ownership information report." Like, there's no, well, gosh, that sucks, you know. And that's the other thing, is if you're drafting operating agreements, or you're doing bylaws, or even your own, you want to put in clauses that say, we care about the CTA. We are going to maintain compliance. We have put in protocols so that we will maintain compliance. And if people don't give us information, then you can put in penalties, like you forfeit your rights to vote on things, or different things like that. I think you're going to want to be able to say to Fenton, we had an oopsie, but we did all the right things, right? Like, here's our policy, and we did this and we did that. So let's see. Any other questions? Anyone want to pop on and ask a question? If not, I think I got all of them. Oh, wait. Okay, we have another one. If the married LLC owner formed the corporation in a community property state, but before December 31st, 2024, moved to a non-community property state, does the LLC owner need to include spouse as a beneficial owner? See, everybody's saying that this area of law is super easy and everybody can just go file these reports. That is one that I would have to think about. But I think my analysis would be, would in a divorce scenario, would the spouse have a right to anything in the business? I think that that's how I would play it out. And I would also look at where the business was formed. I actually have one right now where it's an Arizona LLC, and one of the owners is in Maryland and is married, and we are going to report the spouse because I think that she has an interest. And again, over-reporting is not a violation of the CTA. Under-reporting is, and if you don't have some real specific clarification and you're concerned, I would report. Anybody else? Hi, Stanley. In fact,